Well, welcome everybody. As a member of the Bailey Board of Trustees, I'm delighted to welcome you all here, both literally here and remotely. As you will know, Henry Brooke was the founding chair of Bailey when the organisation was created just over 25 years ago, and the lecture series has been named in his honour. He was, as I imagine we all are, passionately committed to access to justice and the idea that the law should be freely available to all, which are principles that still underpin everything that Bailey does and why we do what we do. We are very grateful to Herbert Smith Freehills Kramer for holding this evening's lecture and making it possible for you to be here and for many other people to attend online. The firm has a long history of generously supporting not simply Bailey, but lots of pro bono charity work. And we're very grateful to them for facilitating this opportunity to bring together people who use and support Bailey from all around the world. We're very grateful to them for their hospitality, for their technical support, for the support they give to the world of art, and please look when you can at their portrait awards. Personally, I am overwhelmingly grateful to them for their air conditioning. I cannot think of anything better on a day like today. I just checked, and at 9 o'clock this evening, it'll be 30 degrees outside. So if you've brought sleeping bags, this is the place to be. Now, as you know, Bailey was founded in 2000 to promote access to justice by providing free online case law, legislation, and general legal materials, which means that the pro bono advisory sector, students, small firms, chambers, and most importantly of all, perhaps, unrepresented litigants can have access to what we take to be our everyday materials. We reach for an authority, we type in the name of a case, we've got it. And most of us work for or in institutions that can afford to pay for that. The advisory sector can't, unrepresented litigants can't, many students and small firms simply can't afford the cost. And so Bailey provides 141 databases of materials. Can I just say some of this I'm reading because some of it I have no idea what it means. But we have all these databases of materials from 15 jurisdictions around the world. And the very, very small team that works for Bailey uploads over 500 judgments a week, here and abroad. We currently have 500,000, so over 500,000 searchable cases available, and that includes 170,000 items of legislation. So we continue to be an essential free resource. We cover multiple jurisdictions, hundreds of thousands of judgments, and we have a deep collection which is getting deeper all the time, pre-2001, going back historically, and in some cases for centuries. We don't use cookies. I do know what they are. We don't use trackers. And the website is regularly consulted by millions of people. In 2024, there were 148 million page views, generated by 14 million users. In 2025, there were 101 million users and almost 317 million page views. For free. Free to the people who are using it, clearly not free to provide. And as a charity, we depend on the generosity of others. We depend on our donors to maintain and to add to our resources. That includes, as I've said, those within the legal professions who use Bailey's services, effectively us, or most of us in this room, but also legal education, litigants in person, and everybody who has limited resources but could actually perhaps contribute something. So we are very, very grateful to those of you from firms or chambers or other organisations that contribute to Bailey, and also to those of you as individuals who donate to the giving campaigns which we run. But we continue to need support. If you use Bailey, or even if you don't, I hope you'll consider doing something to help support, because it must exist. Even if you don't need it, somebody else does. Now, our very distinguished speaker is going to come to the microphone in a minute, and after her presentation, there'll be a short question and answer session. There'll be microphones here in the room for those of you present. Those online have already or can submit questions as we move along. At the end of the lecture, one of our other trustees, Professor Rachel Mulherron, will end the formal part of the evening, after which those of you who are here, sadly remote hasn't achieved this yet, but those of you who are here who are very welcome to join us upstairs for our reception. Those of you who are watching online, you'll just have to open a bottle on your own. Mm-hmm. So to introduce our speaker, Lady Wise, Morag Wise, President of the Scottish Tribunals, Inner House Judge of the Supreme Courts of Scotland, a graduate of the University of Aberdeen and of McGill, Montreal. She qualified as a solicitor in 1989 and began her career in general civil litigation. She was called to the bar in 1993 and after that began to specialise more in family law. 2005, she became Queen's Counsel, and from 2008 began to sit as a part-time judge while still in practice. She was appointed as a Senator of the College of Justice, the Supreme Courts of Scotland, in 2013, and has sat as a judge of the Employment Appeal Tribunal for 3 years. Until December 2018, Lady Wise served as one of the 2 family court judges in the Court of Session prior to her appointment to the Inner House in January 2022. She continues to chair the Family Law Committee of the Scottish Civil Justice Council and has been an International Hague Network judge since 2017. She was appointed last year as an ad hoc judge of the European Court of Human Rights in Strasbourg, and her views on the 21st century judge are guaranteed to be both entertaining and incisive. And we hope that they will provoke you to provide her with really difficult questions. So start now. I'd like to ask you, please, if you would, to join me in welcoming Lady Wise, Morag Wise.
Well, thank you very much, Maura, for that kind introduction and for inviting me to speak this evening. While I wasn't fortunate enough to meet Sir Henry Brooke during his lifetime, I have become quite well acquainted with him recently through what he called his blog site, begun as an experiment to post his extrajudicial writings. Between its incipience in October 2015 and the last post in January 2018, the month of his death, the blog was an impressive repository for Sir Henry's views on many pressing justice issues. So much so that he was described by the then chair of the Criminal Bar Association of England and Wales as the doyen of legal bloggers. His far-sighted commentaries on contemporary legal issues have inspired in part the topic of my lecture. Contributing to legal discourse in such a contemporary way could identify Sir Henry as the very paradigm of the 21st century judge. We can all, I hope, concur with the view expressed by Lord Radcliffe, who in 1968 described the essential ingredients of the 20th century judge as one who was wise, learned, and objective. One might regard these as prerequisites for holding judicial office, but are they sufficient in the 21st century? And will any of these attributes still have value in the 22nd century? Axiomatically, we live in an age of uncertainty. To what extent does the judiciary's role provide certainty and consistency in troubled times? Do threats to judicial security threaten democracy itself? What can the judges do to avoid such threats? Could judges do more to inspire the public's confidence about their decision-making? And what lessons can we learn from the mistakes of the past? It may now be regarded as mundane to note that privilege or the exercise of power necessarily imposes responsibility, but the adage has never been more applicable to the role of a judge than currently. While the substantive duties of the 21st century judge are court and subject matter dependent, the preeminent requirements of independence and impartiality remain essential components of the judiciary's role in upholding the rule of law. Independence in individual judicial decision-making may now be regarded as a subset of the overriding doctrine of the separation of powers. Judicial independence from executive power has a long and proud history throughout the United Kingdom and its constituent parts and former constituent parts. For Scots, an important early illustration is provided by the case of Bruce against Hamilton in 1599, when King James VI of Scotland intervened in person in the debate on behalf of one of the parties. George Nicholson, Elizabeth Tudor's agent in Scotland, reported the court's response to his master Cecil in London in this way. The Lord of Newbottle then also stood up and said to the king that it was said in the town to his slander and theirs that they durst not do justice but as the king commanded them, which he said should be seen to the contrary, for they would vote against him in the right in his own presence. And the lords then so voted. Whereas the king raged marvellously and in great anger with the Lords of Session, the king swears he will have Mr. Robert Bruce's case reversed, which the president, that's the president of the Court of Session, understanding says he, the president, will pen in Latin, French, and Greek to be sent to all the judges of the world to be approved, and that by his vote it shall never be reversed. Sir William Coke displayed the same fearless judicial independence for England and Wales in 1610, when as Chief Justice he declared the king to be subject to the law, famously stating in Dr. Bonham's case that the laws of Parliament would be void if they violated common right and reason. Much debated as a possible early example of judicial overreach, of course, but for present purposes, another powerful illustration of the strength of the judiciary's determination to decide cases without fear or favour. Moving forward a few hundred years to the 20th century, an intense political history set the scene for the Supreme Court of Ireland's historic declaration in 1950 that key provisions of an Act of the Oireachtas, the Sinn Féin Funds Act 1947, were unconstitutional. An engaging article by Gerard Hogan, Senior Counsel, now of course Justice of the Supreme Court of Ireland, marking half a century since its conclusion, brings the controversy to life vividly. When Sinn Féin had split following the peace treaty of 1922, the original organisation resolved, on the motion of its vice president, Michael Collins, to vest a substantial struggle fund, something like £6 to £8 million in today's money, donated by supporters in its president, De Valera, as trustee. The original trustees of the money, who were pro-treaty, subsequently refused to hand over the funds to the anti-treaty faction. For 25 years, a dispute, albeit unlitigated, brewed about the identity of the true successor to the original party and so the rightful owner of the funds, which had meantime been lodged in court by the survivors of the original trustees. It wasn't until proceedings were pending before the High Court for their recovery, albeit making halting progress, that a bill was introduced in the Oireachtas by de Valera as Taoiseach, but now antagonistic towards the reconstituted Sinn Féin, and the bill was passed providing that a new body would hold and administer the money. Strikingly, the legislation provided that the High Court would require to dismiss the pending Sinn Féin Fund's case on the application of the Attorney General. Such an application was duly made but refused by the President of the High Court. And when Mr. Andreas O'Keefe for the Attorney General claimed at the hearing to be at a loss as to the way in which the Act could be considered unconstitutional, the President of the Court responded, because judicial power is vested in the courts. This is a judicial matter brought before the courts for judicial determination. No other organ of the state, in my view, has the right to interfere pending that judicial determination. The subsequent refusal of the government's appeal to the Supreme Court was justifiably hailed in the Irish press as a triumph for the independence of the judiciary. In the modern era, challenges to judicial independence are frequent and require appropriately robust responses. One current concern is the extent to which judges are pilloried in the media in relation to their decisions. And I may say I wrote this paper prior to what many regard as the extraordinary statement yesterday by Prince Harry and Baroness Lawrence about Mr. Justice Nicklon's decision. Strident criticism of any judicial decision is an acceptable aspect of the principle of open justice. Public calls to discipline or remove judges for individual sentencing decisions is not. The recent sentencing decision referred to the Court of Appeal in relation to non-custodial sentences on 3 15-year-olds convicted of the rape of 2 girls illustrates the point. Now, putting to one side the merits of the decision, now of course partly overturned by on Crown Appeal, it is the signing by more than 200,000 people of a petition calling for mandatory sentencing reviews and powers to remove judges from office that are actually used that exemplifies the persistent level of public misunderstanding marked by an increasing tendency to call for the removal of any judge who may or may not have erred in making a judicial decision. The failure of the Crown Prosecution Service to correct errors in the colourful reporting of the case appears to have compounded the problem. Our Supreme Court has recently had occasion to reiterate that the constitutional principle of the judiciary's independence from government still rests on the separation of powers, enshrined now in statutes covering the constituent territorial jurisdictions of the UK. That crucial principle informed the Apex Court's decision that the relationship between a judge and government is fundamentally not akin to an employment relationship. In consequence, the individual concerned in that case, found by a fitness for office tribunal to have been sexually harassed by the judicial office holder, must now pursue her claim against him personally, risking his inability to satisfy an award. While understandably disappointing for that litigant, the consequences of treating judges as effectively employees of government would have been far more constitutionally unpalatable. The High Court of Australia reached a reassuringly similar conclusion when overturning the Federal Circuit Court's decision to allow a litigant to sue a judge for false imprisonment. Despite the lower court describing the judge's conduct giving rise to the proposed claim as an affront to justice, in his reckless disregard for the litigant's rights, his behaviour could not expose him to a civil claim. As the High Court observed, judicial immunity does not exist for the benefit of individual judges. It serves the public interest in preserving the ability of an independent judiciary to act without fear or favour. I want to turn to judicial appointments. In the realm of judicial appointments, independence from the executive is a relatively recent phenomenon in the UK. While each of the 3 territorial jurisdictions now has an established judicial appointments board or commission, their creation ended a long history of blurred lines. In Scotland, for example, the Lord Advocate, head of the prosecution service and a government law officer, customarily appointed himself to a senior judicial vacancy at the end of a term of office. As one judge, Lord Stott, is recorded as having quipped immodestly, "I appointed myself, and a jolly good judge I turned out to be." The metamorphic shift in attitudes to what is fair in judicial appointments since then is perhaps best illustrated by the Court of Appeal's decision last year, supporting greater transparency in the information given to candidates for judicial office about those who will be consulted on their application. A system that failed to make such candidates aware that consultees would be permitted to include comments, in that case adverse comments, they had received from sub-consultees, offended the statutory requirement to conduct the selection process fairly, albeit that the candidate had failed to establish substantive unfairness in the rejection of her application. So judicial appointments, at least in the UK jurisdictions, are now transparently free of the secret soundings and taps on the shoulder that the statutory regimes aim to consign to the sphere of historic interest. Complacency in this regard could yet be misplaced, however, as at least one political party in the UK appears to support the abolition of the Judicial Appointments Commission for England and Wales. Whether the consequence of that being enacted would be a return to direct political involvement in such appointments is unclear. A marked increase in challenges to judicial independence from political interference in the judicial appointments arena has been experienced quite dramatically a little further from home. Since 1989, Poland has benefited from a National Council of the Judiciary, the NCJ, tasked with safeguarding the independence of courts and judges. One of its functions is to assess and propose candidates for judicial office. Following parliamentary elections, a so-called reform of the judiciary was initiated in 2017 and implemented by successive amending laws. The key change involved the process of recruitment to the NCJ, previously through election of the candidates by their peers, but under the amending law by parliamentary appointment, thus allowing Parliament to influence judicial appointments. Even prior to the changes, there had been an absence of protection against arbitrariness in the appointment system, with no provision for judicial review. One challenge exposed that the President of Poland had refused to appoint applicants to vacant judicial posts, despite their having succeeded in a competitive selection process conducted by the NCJ. An early analysis of the proposed reforms by the Council of Europe's advisory body, the Venice Commission, concluded that they would enable the legislature and executive powers to interfere in a severe and extensive manner in the administration of justice, and thereby pose a grave threat to judicial independence as a key element of the rule of law. There followed a series of challenges to the new system, including to the European Court of Human Rights and the Court of Justice of the European Union. The European Court of Human Rights concluded that the participation in judicial decision-making of judges whose appointments were affected by the procedural deficiencies may violate the right to a fair trial under Article 6 ECHR. In its new composition, the NCJ was deemed to be no longer an independent and impartial body. Likewise, the CJEU found such regression to be in violation of EU law. Efforts have been made to resolve some of the difficulties since the election of a new Polish government in December 2023. It sought an urgent joint opinion from the Venice Commission the following year on a number of issues about the status of the judges appointed by the deficient appointment procedure and the validity of their decisions. The Commission expressed the view that balancing the principle of legal certainty and the need to avoid jeopardising the good functioning of the Polish judicial system, any right to reconsider such cases should be time-limited and considered forfeited thereafter. I suggest that the Polish example represents a stark reminder of the extreme disruption to the operation of the rule of law if judicial appointments cannot withstand scrutiny. Whether to unpick or not the decisions of invalidly appointed judges has also arisen in the UK, where a nuanced distinction has been drawn by the Court of Appeal between those in good faith or not about the invalidity of their appointment. Even the most sophisticated of statutory schemes can go awry. I conclude on this point that the aspiration of independence from government in judicial appointments deserves to be closely guarded. And so to judicial conduct. The twin natural justice maxims of audi alteram partem and nemo iudex in causa sua ought to underline everything judges do. But notwithstanding these ageless imperatives, the 21st century judge may find that notions of propriety have evolved over time. In particular, an arguably more stringent approach to judicial misconduct threatening impartiality is now taken. A Scottish authority from the turn of the millennium illustrates the pitfalls that can face even very experienced judges. The late Lord McCluskey attempted admirably, though bravely, to demystify the judiciary by writing a regular newspaper column. In one such contribution, he referred to the European Convention on Human Rights as a field day for crackpots and a gold mine for lawyers. Regrettably, the publication came shortly after he had refused the appeal of some Dutch drug smugglers whose appeal was based on ECHR grounds. An embarrassing second appeal followed, although the court emphasised that it was the judge's journalistic language rather than his substantive opinion that was problematic. In one of the most infamous 20th century cases involving alleged bias on the part of the judiciary, a trial judge in England referred in his summing up to a principal prosecution witness as a fraud, a sponger, a whiner, and a parasite, while describing the defendant politician as a national figure with a very distinguished public record. No guesses, no prizes for guessing which trial that was. It seems unlikely that in the 21st century, such remarks could be cured by the traditional reminder to the jury that it is their recollection alone of the evidence and on witnesses' credibility that matters. But regardless of the nature of perceived judicial misconduct, methods of addressing it are problematic. Removals from judicial office through misconduct have been extremely rare. In 1992, a Scottish sheriff was so removed on the basis of inability not characterised as misbehaviour. The conclusion was that he suffered from an underlying defect in character, which manifested itself in various ways to the severe prejudice of his functions as a judge. The Fitness for Office panel found that he was completely unable to confine his attention to the evidence which the parties in the case wished to lead. He carries with him onto the bench a wealth of private knowledge culled from various sources, which he employs with no sense of self-restraint whenever he likes to decide cases in his own way, irrespective of the issues which he has been asked to decide. His belief that his own expertise is superior to that of the parties and their witnesses makes it impossible for him to bring an open mind to bear on cases where he thinks he has a contribution to make. Now, most recent cases involving judicial misconduct thankfully fall far short in terms of remedy from the last resort of removal from office. Insofar as there is a trend, these have tended to involve alleged unreasonable or bullying behaviour that offends or at least may give the perception of offending against the requirement of impartiality. Judges who have failed to listen carefully to both sides, who interrupt so frequently or so inappropriately that their impartiality can be called into question, damage the public perception of the judiciary and may even find their decisions vitiated through such conduct. The balance is a difficult one. It has been recognised that modern judges take a more interventionist approach than previously. As Lord Justice Jonathan Baker put it in one recent case, no advocate enjoys addressing a judicial sphinx, albeit that the judge under scrutiny in that case was ultimately found to have descended into the arena by cross-examining witnesses in an unacceptable way. I suggest that the type of hearing makes a difference here. When evidence is being led, judges should be far more circumspect in their interventions than during submissions by counsel. So what is the remedy for a litigant where unfair judicial conduct has occurred? It's now established that the correctness of a subsequent judgment is insufficient to remedy such behaviour and render fair an unfair hearing. Such a decision has been described as written in water. The practice in England and Wales, as I understand it, if unfair conduct by the judge has so tainted the proceedings that the decision cannot stand, is to order a rehearing. Conversely, in Scotland, where authority suggests that the court has no such power, the practice is for the appellate court to decide the case of new itself. But either way, judicial misconduct has the potential to damage not just the reputation of the judiciary, but the delivery of effective justice. When judges exceed the limit of reasonable conduct, such that an unfair process has ensued, there is no choice but to undertake the consequential unravelling of that process. I want to talk a little about threats to judicial security now. On the 3rd of March 2023, 2 Scottish men were convicted of the assault and abduction of a sheriff, Robert MacDonald, in Banff as part of a so-called citizen's arrest, although it was the death threats sent to former First Minister Nicola Sturgeon by one of them that grabbed the headlines. In that and in subsequent cases, such as the assault on a family judge in Milton Keynes, where individual criminal acts have been perpetrated against a judicial office holder, it is uncontroversial that they should be provided with the same legal protections as any other citizen. Less frequently articulated, but widely understood by lawyers, is the principle that an attack on a judge is an attack on the rule of law. But what if those attacks are to the life of the nation itself? The war in Ukraine illustrates most poignantly that the judiciary can be directly affected by security threats to their jurisdiction. Having heard firsthand from a Ukrainian judge who described working in a court where several of her judicial colleagues and officials left the court to fight for their country, became casualties of war and did not return, I approach this subject recognizing that such experiences are incomparable to those faced in the UK. The unimaginable daily challenges posed were eloquently summarized by Professor Dmitry Kamensky, who wrote this early in the conflict. It is really a challenge to do any kind of legal writing when law itself, just like any other aspect of normal life that we take for granted, disappears. When a group of heavily armed troops comes out of the blue to search your car and the house you have fled to escape shelling in your home city, forget about any type of due process or human rights protection. When a cruise missile strikes about a mile from your house one night with a loud banging sound. When your law school disappears and most of your colleagues, students and friends have escaped to other parts of the country or abroad. When your academic career track with strong, over decade-long ties to American jurisprudence and the legal community becomes more of a personal safety threat than a hard-earned achievement. I imagine that few, if any, of us present have required to consider just how much we would sacrifice to keep the justice system operative in such extreme circumstances. In the 20th century, judges faced the supreme challenges of world war and revolution. It is striking that the judges who are best remembered are those who refused to yield to wartime temptations of expediency or vengeance. Two examples merit consideration. The first is Lord Justice Atkin's majestic solitary dissent in Liversidge against Anderson, refusing to accept that the Secretary of State could deprive those considered to have hostile associations of their liberty without disclosing the reasons. He declared, in this country, amid the clash of arms, the laws are not silent. They speak the same language in war as in peace. The judges stand between the subject and any attempted encroachments on his liberty by the executive, alert to see that any coercive action is justified in law. The second is the principled stance of the French judge Léon Kahn. As a Jew, he had been dismissed from the Cour de Cassation under Vichy's anti-Semitic laws and had lost 3 sons during the occupation. Nonetheless, when approached to preside over the treason trials of the Vichy leadership, Léon Kahn refused on the basis that he could not approach the task without bias, a decision demonstrating an almost unimaginable level of integrity. This legacy was reflected more recently in Mr. Justice Wilkie's sentencing remarks following the conviction of Joe Cox, MP's murderer, who was described as having been betrayed the quintessence of our country. That the judiciary charged with imposing punishment on those who threaten democracy may on occasions be victims of such conduct themselves has presented itself as one of the most acute dangers for the 21st century judiciary. And so to potential. Whither the role of judges in a world of artificial intelligence. Moving from the troubled past to, one hopes, a brighter future, it's hard to keep pace with the volume of contributions on the subject of AI and the law. As recently as this morning, a Franco-British Lawyers Society seminar entitled Artificial Intelligence, Friend or Foe took place in Edinburgh, with contributions from distinguished French and English judges, one of countless, though necessary, discussions about the extent to which AI is transforming the way we all work. There's no time this evening for more than a brief foray into one of the many pertinent questions in the debate, namely whether the distinctly human aspect of judging will survive this revolution. As one member of the Australian judiciary has observed, judges are not reasoning machines. But for how much longer? Judge Richard Posner, formerly of the United States Court of Appeals for the Seventh Circuit, drilled down somewhat controversially into the je ne sais quoi of judging, albeit not in the context of AI, saying, "I pay very little attention to legal rules, statutes, constitutional provisions. A case is just a dispute. The first thing you ask yourself, forget about the law, what is a sensible resolution of the dispute? When you've got a Supreme Court case or something similar, they're often extremely easy to get around." So we might ask, is the nebulous but precious common sense the irreplaceable judicial commodity? Posner's approach was radical and contradicted the accepted norms of decision-making through strict legal analysis. One eminent academic concluded a review of Posner's book Overcoming Law by observing, "Well, I for one would cheerfully surrender custody over my fundamental rights and liberties to the supremely reasonable Richard Posner, but I'm less inclined to give similar discretion to many of his judicial colleagues." And what of compassion? Could it be the key trait that survives machine-led thinking? Although compassion, while a universal value, is not one which is without dispute. The line of authorities relating to the withdrawal of life support demonstrates that point well. Compassion in that context may look different to a utilitarian, a consequentialist, a Catholic, a Muslim, a parent, or some combination of those. What compassion means to different people, and so to different judges, will vary. So much has been written about all of this, it's hard to distill succinct thoughts from the plethora of sources. However, recent contributions, such as those of the outgoing Master of the Rolls, have focused on the aspects of judging that may yet be left to human beings. A view that is gathering support in this context is that judges working in fields involving human interest may find themselves more in demand than ever. One such example is family law, particularly child protection. There can be no higher stakes in judicial decision-making than when judges require to resolve live practical questions between individuals or between the state and individuals. The enormity of the task was articulated persuasively some years ago by Mr. Justice Nicholas Mostyn in a letter, The Craft of Judging and Legal Reasoning. He said, "I have tried in child protection proceedings cases where the issue is whether a parent has deliberately killed a child. In effect, in such cases, I sat as a diplock court trying a charge of murder. In the light of such findings, I have been asked to order and have ordered forced adoption, severing the parental bond. In the Court of Protection, I try issues of mental capacity, and in light of the findings, have been asked to order and have ordered forcible caesareans or amputations. I have been asked to make findings as to the life expectancy and quality of life of seriously ill and damaged babies and adults in support of an application that medical care should be made palliative only and that the person should be allowed to die." Transposing that to the current discussion, I find it hard to conceive of such decisions being made by reasoning machines. When Lady Hale said that judges can and should be human and not alien creatures, the context was not any feared or anticipated destination for AI, it was rather about the need for a judiciary representative of the public it serves. And while the sentiment that judges should have human compassion is a respectable one, the received wisdom is that they must be alert to the dangers of allowing considerations beyond the law to influence their decisions. In a fascinating book entitled How Judges Judge, Brian Barry, an Irish academic, examines several thought-provoking topics on judicial decision-making. These include cognitive biases, errors in numerical evaluation, motivated reasoning, emotion, and group decision-making effects. These are uncomfortable concepts for judges even to contemplate, schooled as we are in the fundamental ethos of impartial decision-making. But let me pick just one example, that of the role of emotion in judicial decisions. Barry cites examples of judges making statements that appear to go against what he terms the persistent cultural script of judicial dispassion. First, there is the statement of an English family court judge who stated, "I couldn't read out the judgment, I just had to hand it down in writing," to describe his emotion in a case involving a child being taken away from her young mother. The written judgment itself expressed his sadness and regret at coming to the wretched conclusion, his words, that the child should be so removed, and anger at the care system that appeared to have let the mother down. And there is the story of a Canadian judge who was seen to dab a tear from her eye when reading a victim impact statement in a sexual abuse case, and who was then asked to recuse herself. Refusing to do so, she declared that there is nothing wrong with the court showing emotion, and that demonstrating human compassion was not the same as judicial bias. Academic writers have attacked these and other examples as inappropriate, arguing that to call a judge emotional is a stinging insult signifying a failure of discipline, impartiality, and reason. This single example exemplifies the minefield that is the psychology of judicial decision-making, a subject on which I claim no expertise. But its relevance to the issue of potential for future judicial decision-making may be to consider whether properly channeled, the human aspects of judging may yet be our USP. It seems to me that taking care to discount personal bias should not deprive judges of empathy where appropriate, even at the highest level of decision-making. In a short but impressive biography of the late Lord Roger, the point is neatly articulated. Remarking on the sensitivity Lord Roger displayed in his searching remarks about whether and how a tribunal could measure the suffering which a gay man would find reasonably tolerable in the case of H.J. Iran, David Johnson KC records that this was a judge who brought innate human sympathy to his judicial work, in addition to meticulous legal analysis. So, how will the 22nd century judge navigate this quagmire? If reasoning by deduction, induction, and analogy can all be performed perfectly well by artificial intelligence, will it be the peculiarly human elements that will continue to justify our existence as decision makers? Discussions about these elements within judicial decision making are hardly novel. They predate the current explosion of contributions on judging and AI. In 1999, Michael Kirby, the esteemed Australian jurist and academic, put it this way: decision-making in any circumstance is a complex function, combining logic and emotion, rational application of intelligence and reason, intuitive responses to experience, as well as physiological and psychological forces of which the decision-maker may only be partly aware. The discussions about replacing judges with AI bots are redolent in some ways of the debate that took place during the COVID-19 pandemic. The courts quickly adapted to online hearings so that the business of judicial decision-making could continue. In some quarters, Scotland being one, this was considered so successful that questions arose about whether the need for in-person hearings could be dispensed with in the longer term. Many of us felt that ignored the importance of the sense of place that courts and human judges provide when dispensing justice. In his ongoing work about courtroom movement, James Campbell at Oxford draws on legal architectural scholarship in describing the space that we call a courtroom as the setting for a ballet previously choreographed but yet to be performed. Using Court 1 in the Court of Session in Edinburgh as the paradigm, Campbell comments on the court's innovations, such as the embracing of live streaming its hearings. He comments that this push for transparency through technology is admirable and may go some way towards demystifying the arcane. Alternatively, it may simply disseminate the arcane to a wider audience. Either way, it seems to me that if we jettison those publicly recognisable and well understood aspects of the art of judging, we do so at our own peril and that of the as yet unborn 22nd century judge. Human impact hearings within public inquiries, such as the Post Office and infected blood inquiries, are good examples of the aspects of judicial work that investigate much more than the rights and wrongs of a system or incident. They require a human face. So, having made significant progress towards blending technology into the important physical space of the courtroom, just how looming is the threat that human judges won't be occupying it? We must be alive to the extent to which artificial intelligence might supplant judicial decision-making as opposed to providing assistance with it. Returning to Brian Barry, in concluding his work by examining the case for and against AI judges replacing the humankind in future, he acknowledges that such judges will be able to provide good quality judgments more efficiently and accessibly than their current human counterparts. But this is to be balanced by the view that justice is not just a product, it is also a process. He states many litigants crave the sense that they have been listened to, that they have had their day in court, and that they have participated in a civic exercise under the watchful eye of the public. That reflects, I suspect, the experience of most of those of us who've spent their professional lives in the courts. So, there are recurring themes in considering the privileges, pitfalls, and potential of and for the judiciary. As in so many walks of life, we can learn from past mistakes. I want to conclude this survey of 21st century judging with an optimistic word directly to those of the century to come. To paraphrase the enduring words of Mark Twain, I am confident that rumours of your anticipated demise are being greatly exaggerated. Thank you for listening.
Thank you very much. And now the opportunity for the really difficult questions. Yvette has a microphone in the room. Are there questions online? They're coming through.
Thank you so much, Lady Wise. Thank you. Thank you so much for your inspiring talk, and I learned a lot from you. I just would like to understand why the role of judges in the UK, in particular in judicial mediation, different from some other jurisdictions, such as China, where the same judge who conducts the mediation could later, in fact, decide the case, if the case proceeds to the hearing. So beyond the principle of judicial impartiality, is this difference linked to UK legal culture or traditions? Thank you.
Thank you for your question. So judicial mediation is not something that is prevalent in my jurisdiction in Scotland. I know that it has had some success, I think, in England and Wales. My understanding is that there are very limited circumstances in which a judge who had conducted a judicial mediation would then go on to try a case. I think that, and anybody from this jurisdiction can help me out if I'm wrong, but it would be unusual, I think, for someone to conduct a form of mediarb or judicial mediation and then conduct the case.
Thank
If you'll excuse me, I'll start with an anecdote. In 1975, I was Henry Brooke's pupil. And when he discovered that I was doing work in spare time for Amnesty International, his comment was, "I don't know why you're doing that, Peter. There's no future in human rights." Henry obviously changed his mind. To what extent is it essential? To what extent do we and can we expect judges to have an open mind and persist with an open mind? And if they do change their mind, how do we guarantee it's not the result of bullying from the senior judiciary?
Well, there's quite a lot in that. Let me deal with what I think is a slightly easier part, and that's the open mind aspect. One of the things that the judiciary in my jurisdiction is wrestling with a little is the fact that we front load cases so much more than we used to. And the same happens in England and Wales, and you see it in the Supreme Court too. And the way we work now is that no judge comes to court with an uncluttered mind. You've read the papers, you've thought about it, at my level, you've had some assistance from judicial assistants and so on. So you have a tentative view. The trick is in making sure that it is no more than a tentative view that will inform the sorts of questions that you want to ask counsel who appear. So a closed mind is something that we very much try to avoid and that we are very much more aware of because of the way in which we now work. And the system works reasonably well because it allows you to question counsel, as I say, much more carefully and in an informed way. The second part of your question, in terms of sort of bullying from judges higher up, has a very serious side to it. And I hope you don't think I'm being naive, but in my judicial career, I have never been bullied into making a decision to go with the zeitgeist or with the mantra of some more senior judge. So I'm not quite sure what you're referring to, whether you're referring to a court in which there are more judges sitting, like an appellate court where you have three. Yes, that is what you mean. Yeah. Okay. So when I was a first instance judge, there was no question of anyone trying to influence my decision making. And you would expect that's one of the things I was alluding to in my lecture. The court I sit in at the moment sits usually as a bench of three, like the Court of Appeal in England and Wales. We sometimes know before we hear the case who is likely to be taking the lead in the judgment, maybe because they have expertise in the area or just they've managed to do more preparatory work. So sometimes we know in advance, sometimes we don't know till afterwards. The question you ask may, I don't want to make any assumptions, arise from the fact that academics are writing about the fact that there is less dissent nowadays from courts. And there's no doubt that that's the case. I mean, I haven't got the statistics at my fingertips, but I know that both in this jurisdiction and in the one in which I sit, there seem to be fewer dissents. My experience is that that's not because of bullying from a more senior judge. It's because we take the time to have deliberations. We have the front loading I discussed, and then we have time to deliberate afterwards so that if we can reach consensus, we do. I have been involved in deliberations where it looked as if we might not reach consensus, and I have been prepared to dissent if that's the case. Sometimes a further meeting or discussion means that actually you do all come round to the same view, but I don't think I would describe it ever, I wouldn't describe it ever as bullying, and I'm not sure I would even describe it as, the more senior judge being very persuasive, not casting aside the tradition they had at the bar of persuading judges now wants to persuade their colleagues. It's actually more that one hopes the correct answer will emerge from those discussions. if there is a tendency to look unfavourably on dissent, then that would be a concern for the judiciary. Yeah.
Sorry.
Lady Wise, there is a question from a person online who asks you, how widespread do you think Posner's view of judging is in practice, regardless of the theory?
So I think I threw that in perhaps to spark a little controversy. Again, I can only speak for my own jurisdiction. I think a common sense cross-check is absolutely essential sometimes, but I don't think that there are many judges who will, as he described, sort of throw aside the statutes and the cases, because any first instance judge doing that will find themselves the subject of an appeal from their decision. But as a cross-check, I think that once you have worked out what the answer is having regard to the trend of authority and applying it to the facts of the case and so on, there is no harm in a common sense cross-check. I think there's somebody.
Hi. In England and Wales, increasingly in judgments, you're seeing a paragraph where basically the court says, we are not deciding the zeitgeist controversial social issue.
Yeah.
We are about this.
Yeah.
Do you think that is a good practice for judges to adopt, or do you think it represents the consequences of a chilling effect on judicial expression in judgments, that because they know it's going to be quoted, for example, in social media or by politicians?
Yeah. So I think the concerns we have about being pilloried in the press are quite real. I think that people don't, under this audience, will understand the boundaries of professional criticism, which is acceptable. But I think out there on social media, it is very different. That said, I don't consider it's acceptable for judges to be commenting on matters of policy anyway, in their judgments. And if I dare take the example of gender identity and the For Women Scotland case, where I was the first instance judge in an earlier stage of the earlier case, and made such a statement, the very statement that you are describing. I think one has to do that because it's a legal decision. It's not a decision. Whichever party succeeds will publicize your decision as if you are a promoter of whatever they are advocating. And of course, that's not what judges do, and it's not what we're there for. Is it now an overused paragraph in a judgment? I don't know. If it is, it's unfortunate that it's come to that, but sometimes it's necessary just to clarify that this is not a political decision, it's not a social policy decision, it's a legal decision.
Thank you.
Perhaps another question on, I'm so sorry, just one question
Okay.
online, and then perhaps the gentleman at the front. To what extent does the fact that one judge having a particular specialism, say family law, to what extent does that influence the opinion of other judges during deliberations? One person online has asked.
Yeah, so I think that's a really interesting question because in my jurisdiction, all judges are generalists to the extent that we're just not big enough to have, we don't have a family division really, or a chancery division. I know they've renamed the chancery division and I've forgotten what it's called, business and property. And so we all do everything. But inevitably, those of us who were specialists at the bar will bring to the party a hinterland of information, knowledge, and experience in a particular area. My own experience, for what it's worth, is that sometimes the judges who can be most vocal in areas that they did not practice in are the ones who are not specialists in the area under discussion. perhaps that comes back to Richard Posner's common sense, but I'm not going to name anyone, but I do find judges are quite willing to roll up their sleeves and get involved in areas in which they had no experience at all at the bar, or maybe even as first instance judges, but when they get to the appellate court, gain sufficient knowledge to express their views just as vociferously as anyone else.
We have time for a final question here at the front.
Thank you very much. Commercial litigation and trials, at least in the Rolls Building and the Business and Property Courts, are getting massive, often running 6 months and longer. The documents run into the millions, the facts are huge, and the issues can be in the number of scores. At the moment, it seems to muddle along with having very long trials, but is there a future, in case these sorts of trials get more frequent, that multiple first instance judges will sit on a single trial to even out the judicial workload, or otherwise will trials be split more often to ensure that findings of fact can reasonably be made within a shorter time span than what we see now?
So I think that part of your question perhaps will be answered by some of the technology that I was discussing. I think that there are positive ways in which we might be able to use artificial intelligence to cut down the amount of work that an individual judge has to do in a case. Now, we're just in the foothills of this, and it's not been worked out at all. In my jurisdiction, it's a little bit further ahead here in terms of regulating what judges can use. But that's one thing I think that can be done to try to get into a more civilized state some of these enormous cases that you're talking about. I think that in terms of dividing a case between different judges, I think it's a very specific question you're asking related to that type of litigation. It can be possible, but my overall feeling is that the drive towards efficiencies, concerns about resources, concerns about judicial resources and there being enough available, means that other ways will be found to limit the paperwork. It's all electronic now.
Yes, certainly. Yes, just one final question. This gentleman at the front.
Thank you. Sort of related to the AI things, you were saying how the more human areas, the law probably have more of a stronger argument to say that human judges should stick around. Do you think that towards the business and property or more commercial cases, there's more scope for automated decision making or AI judgments or something like that?
Yes and no. I don't want to offend any business and property colleagues. But I think what I was trying to convey was this: if you have a case that is about money and about how many millions or tens of millions required to be paid to compensate another party, it's easier to see that you can feed that into a reasoning machine and get an answer. In the very acute situations involving people, whether it's criminal law, family law, disputes that involve human beings, I think are more likely to survive the AI revolution.
Thank you. Thank you very much. Very beautiful lecture. So I just did an experiment here. So I wanted to ask one question, and I asked artificial intelligence, can I ask this question? It said, no, change it a little bit. So I asked both questions.
Okay.
So my question was, do judges or tribunals who regularly rule in favor of the state have prospects of promotion than those whose decisions more often favor individual litigants? Hey, I said, no, don't ask this. This is too much direct. Ask. Do institutional culture tend to reward judges who are cautious than the activists?
So we're ending with a very controversial question. And I'm not going to avoid answering it, but the whole thesis that I'm trying to put forward is that judges have to decide every case impartially, without fear or favour, and certainly not in favour always of one side or the other. In fact, it would be a huge concern if a judge was seen to be favouring the state, or indeed always favouring the individual against the state. And so a case-by-case approach hopefully doesn't happen, and certainly wouldn't result in promotion.
Well, on that controversial note, I think we might just draw the event to a close. It gives me great pleasure to do that on behalf of Bailey. Thank you to all of you for taking the time to join us this evening. And thank you again to Herbert Smith Freehills Kramer for their generosity and hospitality this evening. And I would particularly like to thank Lady Wise on behalf of the trustees of Bailey for travelling down from Scotland in a heatwave to favour us with her fascinating lecture, the Sir Henry Brooke Lecture for 2026. I'm sure that everyone here found it as thought-provoking as I did. In fact, I thought that the lecture itself embodied those three characteristics which Lady Wise outlined as being prerequisites for judicial function right at the commencement of her lecture, which was that it was wise, learned, and objectively and forensically examined. With respect to Bailey, I would like to just close on two additional points to those that Maura mentioned at the beginning. First of all, as trustees, we're very keen to ensure that we improve Bailey and that we have meet the market with respect to what would be useful for those chambers, law firms, etc., who use the Bailey service. So in that regard, if there are any members in the audience who would like to partner with Bailey or would like to speak to the Bailey representatives about how we could assist or how you could partner with us, then please do so, and Yvette and Anne would be happy to speak with you about that. And the second point is that, of course, as Maura mentioned, we are a charity and we do depend upon donations. So if you do feel minded to help us in that regard, then there is a donate button on the Bailey homepage, and there's also a QR code on the screen should you wish to make use of that. But finally, thank you to everyone, both in the room and online, for your attendance at this excellent lecture this evening. With respect to the logistics of the matter, I'd like to invite our in-person guests to join us upstairs for a glass of wine or two, and I wish our online guests a very pleasant evening. With respect to the logistics, moving upstairs, please don't worry about your coats and bags. The cloakroom staff will move everything for you. And when you leave this evening, please do return the name badges if you can remember. But finally, please join me in expressing our heartfelt thanks to Lady Wise for a brilliant lecture. Thank you.